All rise. Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Patricia J. Millen presiding.
Good morning. You may have a seat. We have one case today. Today is February 2nd, 2026. We have an appeal from a findings and order of Ronald Brand versus United Road Service Midwest and its insurer ESIS Chubb. The employer and insurer have appealed. Their attorney representing them is Feryanchek. Mr. Feryanchek, did I say it correctly? Yeah. Thank you. The attorney representing the employee is Attorney Boyce. Thank you. Oral argument is recorded and the link is on the WCCA website. We are here in file number 25-6616. We have a 3-panel court this morning. I have Tom Christensen, Judge Christensen on my left, and Kathy Carlson Hip, or Hip Carlson, I'm sorry. Oh, you don't go by Hip? Okay. And Judge Carlson on my right. As stated, my name is Patricia Millen. I am the Chief Judge of the WCCA. Each of you have 15 minutes to present your opening statement. You will start with 3 minutes of uninterrupted time to state your position. At the end of the 3 minutes, I will stop and I will ask my colleagues if they have any questions. Does anyone have any questions before we begin? None. Thank you. Mr. Feryanchek, you are the appellant. Please proceed to the microphone.
Good morning. May it please the court. Before I begin my argument, I want to thank this court and counsel. 2 weeks ago, I had a bout of bronchitis and it needed to be rescheduled, so I appreciate the accommodation. Unfortunately, you're going to hear me hack quite a bit today, so I'm going to do my best. I've taken quite a bit of medicine and hopefully we can make our way through this. But as it relates to the appeal, this case turns on a single statutory question of whether or not Mr. Brand regularly performed primary duties of employment in Minnesota under 176041 subdivision 2. We believe that the record confirms he did not, and that should end the jurisdictional analysis. Minnesota jurisdiction is not triggered by incidental or temporary work. It requires the performance of core work. Mr. Brand did some minor tasks on some minor occasions after the employer allowed him to drive home, but none of those were regular or primary. This is not a denial of benefits case. Another state has jurisdiction and it has fact paid benefits to Mr. Brand. He was hired in Michigan by a Michigan company. He was dispatched from Michigan and Indiana. He shipped loads to Iowa, Illinois, and Wisconsin. No loads were delivered in Minnesota, and the accident happened in Wisconsin. The Minnesota Supreme Court has consistently stated that regular means customary, usual, and predictable, not irregular and casual. The statute requires a real employment relationship in Minnesota, not just a residential connection. If hauling freight under the Hoffman and Long decisions are not primary duties, then a 5-minute inspection on 3 occasions and filling up with gas doesn't even come close. His placement in the state was driven by convenience, not the actual work. The employer allowed him to travel home if he was in a certain proximity. And if he hadn't lived within 100 miles of his final delivery that occurred in Wisconsin, he would have never been allowed to drive home. The only evidence in this case that he was in Minnesota are those 3 visits. This case is more like a long drive home after a day of work. But somehow this court have elevated getting gas and 3 5-minute inspections over the actual work of delivering freight. 3 visits amount to 0.0003 of the time spent is not consistent work in Minnesota. In this case, as I said earlier, there were no loads ever shipped to Minnesota. And although time spent isn't a controlling situation in terms of cases, it's a factor.
I'm going to stop you right there. Thank you. Do either of my colleagues have a question?
Thank you. Good morning.
Morning.
My first question is, what is the standard of review? Tell me what you think it is.
Standard review is clearly erroneous, but in this particular situation, I believe that the case is clearly erroneous based upon the facts in this situation.
And do you think it's clearly, what findings specifically do you feel was clearly erroneous?
When the judge concludes that there is jurisdiction because of the 3 visits, that's clearly erroneous. That is the error undertaken by the judge. That is insufficient to create a contact with the state. When she concludes that getting gas and doing a 5-minute inspection is a primary duty.
So to be more specific, in finding number 43, the judge found by preponderance of the evidence, the employee regularly performed some of the primary duties of his employment in Minnesota. So the finding of the primary duties being done in Minnesota, is that clearly erroneous?
Correct.
And is it because of the definition of the word primary?
Correct.
Do you think there can be an argument made that the judge misapplied the law, misapplied 104 sub 2 to the facts of this case?
I think it's part and parcel. I do. I mean, I have to face in front of you head on with her factual decisions. I believe under any circumstance, if those 3 instances were looked independently from you on a clearly erroneous standard, it doesn't meet it. But I also think she applied the law incorrectly, which is a de novo standard. But I'm still faced with the factual findings in front of this court, and I have to come forward and be prepared to address that. But there is absolutely no basis for a court in this particular case to conclude that those 3 inspections are work. The primary I'm sorry.
Yeah, I have many questions, but I want to make sure I'm not hogging the time for the other judges. And again, in finding 43, the judge found that the employee regularly performed some of the primary duties of his employment in Minnesota, whereas the statute requires the primary duties. Is that important to you at all, the word some?
Absolutely. And we analyzed that in our brief, and there's a specific paragraph about some and how she parceled that particular statute. That's an absolute incorrect application of the law. I mean, when she said that sum is sufficient, that's not correct. When you look at Long and Letourneau and all those cases that we've cited in our brief, those are specific instances in which an individual did some more work in the state of Minnesota than what we have here, and they still found no jurisdiction.
And the other question I have before I pass it on to my colleagues, the question I've been thinking about a lot is, certainly fueling, inspecting, and logging, those are things that are required to drive a truck. My question for you is, can a duty can it be required or necessary but not be primary?
I believe that you need to look at what the primary job duties are in this particular situation. He is a truck driver that hauls freight. None of that occurred in Minnesota. The other issues, the filling of the gas, are merely incidental and are not in any way, shape, or form related to his job. Yes, they occur, but it's not as a result of the work. It's just a mere fortuitous situation that he found himself in Minnesota needing gas. And put it in a different context. If somebody's driving through, never does a thing in Minnesota, but exceeds his hour restrictions as DOT drivers can do, and has to spend 4 hours overnight and then fills his gas, now we have jurisdiction for every single trucking company that goes through the state of Minnesota. That's a travesty. I mean, that is not what this state statute was developed for. I get the Minnesota workers' compensation is broad and it favors the employee, and I get the philosophical reasons for that. But it's for Minnesota workers, not transient workers who are allowed to go home to visit their family as a convenience. This gentleman did everything in the state of Indiana, in the state of Michigan, in the state of Wisconsin. The only connection that happened in this particular situation was he was allowed to drive home and see his family, just like every one of us do when we go home at night. That's exactly the situation that we have here.
My question isn't looking at the transcript on page 49, then over on 50. It seems on the day of the accident itself, the employee testified that in fact the inspection that happened was in Wisconsin. It wasn't in Minnesota. And that was the only inspection done on that day. Is that, meet with your memory of the situation in this case?
That's an accurate statement. None of the inspections on the date of the injury had any connection with Wisconsin, or pardon me, with Minnesota. The Minnesota connections were three. If you look carefully at the record, there were 3 transient visits that occurred in the several months before the accident, where he happened to be within 100 miles of his home, and consistent with the employer policy, he was allowed to drive home. It had nothing to do with the accident. It had nothing to do with the load. It had merely to do with the fortuitous location in which he found himself at the time he was allowed to drive home. That's the only situation.
And then on the day of the accident itself, it would appear that he received the assignment not from any terminal in Minnesota, but from the terminal in Indiana, I think that he was working out of. Is that
Indiana.
correct?
United Road has no terminals in Minnesota. United Road does no deliveries in Minnesota. They have no connection to Minnesota whatsoever, other than allowing Mr. Brand to drive home on those rare occasions in which he's close proximity to the accident.
And the record also seems to reflect that on the day of the accident itself, he had made other stops in Wisconsin and was just on his way to another, either picking up or dropping off another load in Wisconsin.
He never crossed the border into Minnesota, ever, aside from those 3 occasions on the record when he was coming home near his residence.
Mr. Ferrianchuk, this is a 2-part question. Number 1, did the employer do anything to subject themselves to Minnesota jurisdiction? And 2, does it even matter? Can there be jurisdiction in Minnesota even if the employer did not subject themselves to that jurisdiction?
There has been no effort on the part of this employer to subject themselves to Minnesota jurisdiction. In fact, it's quite the contrary. This particular employer is well aware of the situations that goes on in terms of evaluating how Wisconsin, Illinois, and other states evaluate work comp. There has been no effort on their part to ever subject themselves to jurisdiction. And in fact, once they lost the Ford plant, and that must have been a decade ago, that's what the record talks about, there's been no trips here whatsoever. No, I don't believe there's any thing. And yes, I think it is important. If there's an effort upon the employer to do something actively in the state of Minnesota, then yeah, I believe this court would have jurisdiction. But there's been no active participation by this employer in any way, shape, or form in the state of Minnesota. If there's nothing further,
I have
Oh,
just
yep.
a quick question. It's a little bit, you put in the subrogation release that was signed by your client as well as the employee. Assuming and hypothetically benefits are awarded to the employee, wouldn't that, your client wouldn't have any subrogation interest because it's already been released? How do you see that issue?
that's why it was added. I mean, we were compelled to participate in the Wisconsin action. We were compelled to seek subrogation of that bodily injury claim in Wisconsin. That release resulted in a $5,000 payment, minuscule compared to what work comp benefits were paid in this particular situation. But we're foreclosed from going back any further. I think this court can take judicial notice. There's an actual underinsured action pending right now in which they're trying to get jurisdiction back in Wisconsin. I mean, not that that's part of the record, but it's certainly available legal analysis for the court to consider. There's a
Do you think we should consider that on the basis of statute?
No.
Okay.
I don't at all. We were talking about that particular release and that's all. No, it has nothing to do with this particular analysis. This analysis depends solely upon this court's decision to find jurisdiction for 3 visits. And I know why it happened. Mr. Brand is the nicest human being you're going to find. He truly, truly is nice individual. But that's not the basis to create law that's going to affect a multitude of employers in a multitude of situations just because they drive through the state and get gas.
Well, Mr. Ferrianchek, I do have a few questions before you take your seat. And how many primary duties do you identify in this position in this case?
The primary duty in this particular case is hauling freight,
It says, statute says duties. So do you have more than one?
driving a vehicle. In this particular situation, it's delivering the freight and making certain it gets there safely. There are the only primary duty that this individual has for his job. I don't think you could create any more duties except to operate a vehicle safely.
And that would be, in this case, the primary duty upon which to measure whether or not jurisdiction comes into play under the statute?
Correct. There
Okay.
has been no effort to haul freight in the state of Minnesota for this individual.
So I'm going to go then back to your seventh pretrial statement that you filed in May of 2025. You said that in your defense, there are no fundamental or basic part of his entire employment that was performed in Minnesota, and the employee relationship was not centered. Pre and post trip checks do not qualify as regularly performing the prime duties of employment. And I didn't see any case law cited at trial or the statute. You're saying that is your position, and the judge found by findings of fact that there were some duties that she believed were primary or rose to a level of primary to fit the statute. Is that a correct statement? And correct me if I'm wrong.
My factual statement in the pretrial statement is correct. Her analysis is wrong. When she chose to limit those 3 visits and that gas station attempt, and then she found that was a sufficient duty, that's what's wrong in this case. It's factually wrong from a clearly erroneous standpoint because there's no way 0.0003 should have reached that level, and it's legally wrong because it's not a primary duty as it relates to his job as a truck driver.
Thank you.
Thank you.
Thank you.
Thank you.
May it please the court. My name is Mary Beth Boyce, and I'm here on behalf of respondent Ronald Brand. We're here today on the basis of the March 27th, 2020 motor vehicle collision, where he was injured in the state of Wisconsin and the motor vehicle collision took place there. However, the compensation judge correctly applied Minnesota statute 176.041 subdivision 2 when she concluded following an evidentiary hearing that Mr. Brand regularly performed the primary duties of his employment on a regular basis within the state of Minnesota. The statute states if an employee who regularly performs the primary duties of employment within the state receives an injury while outside of that state in the employ of the same employer, the provisions of the Minnesota Work Comp Act still apply. This is a case about definitions, the primary duties and regularly performed. The important facts in this case are that he drove loads on trips that would last for weeks throughout multiple states. He returned home to Minnesota approximately once a month. He worked 14-hour days during which he drove up to 11 hours. He was paid per load, not per hour. He maintained a commercial driver's license issued by the state of Minnesota. He was required to undergo annual DOT physicals, and he underwent these physicals in Minnesota. The primary duties are he performed pre- and post-trip inspections within the state of Minnesota. He ensured that his vehicle was compliant with DOT rules. He checked the oil, the radiator, washer fluids, tires, lights, and signals. He inspected his vehicle to ensure that mechanical failure would not cause an accident, and he checked for air leaks in Minnesota. He lifted the hood and physically inspected the vehicle within the state. Notably, he also fueled his vehicle within the state of Minnesota. He secured an area in his property to safely store the vehicle, and he would on occasion use electricity from his home to ensure the vehicle would function in cold weather. He also completed trucking logs within the state of Minnesota. These are, and then in the record, prior to March 2020, he did these on the following dates: January 31st, 2020, February 3rd, 2020, and February 27th, 2020. I want to flesh something out that wasn't clear in the briefs. So when we talked about the primary duties, these are primary duties whether they took place in Minnesota or not. So he would do these duties in Indiana and Wisconsin. That doesn't mean that they're not primary duties. These are still primary duties, but they have to also take place within the state of Minnesota. And it's not the proportionality of, well, he did these last in the state of Minnesota. Yes, he did these last in the state of Minnesota, but these are still primary duties, checking, making sure the vehicle is going to safely operate on the road.
I'm going to stop you right there.
Thank you. Good morning.
Good morning, Judge.
So Ms. Boyce, I'm going to just kind of hop to the heart of it. And you said this is a case about definitions, and to a large extent, I agree, specifically the definition of what is a primary duty. And you heard Mr. Ferrianchek talk about incidental duties. The judge here found fueling, inspecting, and logging to be primary duties, correct?
Yes, Judge.
And Mr. Ferrianchek gave a hypothetical similar to one that I was going to give to you. So if you say fueling is a primary duty, what about the truck driver or worker who's driving from South Dakota to Wisconsin that stops in Minnesota to fuel once a week as part of their regular route? Is every person who stops to fuel, because you needed to go from one place to another, then subject to Minnesota jurisdiction? Is every employer that lets their employee fuel in Minnesota subject to Minnesota jurisdiction?
No, it would, Judge, it would have to depend on, is it a truck driver? So is fueling the truck?
Let's say it's a truck driver, a salesperson, medical transport. There's many reasons why you would need to stop and fuel your vehicle as necessary to do your job.
Maybe. So medical transport, maybe. Truck driver, maybe. Just a salesperson traveling, fueling, happening to get fuel in the state of Minnesota, no, because it's the primary duties. So fueling the truck in conjunction there with the pre and post trip inspections, the logs.
So you're saying it's more of a package?
Yes, Judge. It wouldn't. I don't think you can look at it and just pick that there's going to be, or you can't, that there's going to be some blanket rule that everyone who gets fuel within the state of Minnesota would somehow be subject to Minnesota jurisdiction. It has to be the primary duty. And the primary duty of a truck driver has to be that the vehicles are safe on the road, that they're fueled, that they're checked, that they're checked to be operational.
Sure, but if you even take it a step back, in order to be safe and to be legal, the truck driver also needs their DOT physical, their Class A license, but those things are not primary duties of a truck driver, although they are required. Would you agree with that?
I would agree with that. I think
So
that's
not
fair.
not everything that is required or is necessary to do the job is a primary duty.
I would agree. I would agree on that. But I think that if the purpose of a truck driver is to transport that, which he was hauling cars throughout the state, he can't do that without making sure that his vehicle is operational. So that means it's a core part of the job. Where if you're looking at a salesperson, I mean, are they renting the car? I mean, there's a lot of, it's just all the cases surrounding this jurisdiction, they're very factually dependent. And so I think you have to analyze those specific facts on the record to see if they are primary duties.
And then I'm going to switch you to something else before I hand it off to my colleagues. Do you think well, let me ask you this. Was the employee in Minnesota at the employer's request at all?
No. No, Judge.
Was the employee doing anything to further the employer's business while in Minnesota?
I would say yes, to ensure that the vehicle is operational. But my other part would be that that's not an analysis that's currently in the case law. That, I think that is at, if you're, so I guess it's, I don't believe it's relevant, Your Honor. Similarly, Judge Christensen, it's not relevant whether, there's no disagreement that he was on the date of the injury, he was in Wisconsin. He had not done any of that, any of the pre and post trips in Minnesota, but it's not relevant under 176 041 subdivision 2 analysis, whether he was doing it in furtherance of their business.
Well, then let's get back to the statute. And you heard me ask Mr. Ferrianchek this. The statute provides that the employee has to regularly perform the primary duties in Minnesota. The judge found some primary duties. Any problem with that?
No, Judge, it's, none of the case law requires that it's all the primary duties, some or the primary duties. She found that he wasn't performing all of the primary duties in the state of Minnesota. But he was performing the primary duties. And again, those duties are primary, whether they take place in Minnesota or whether they take place in Wisconsin or Indiana. And he was regularly performing those because the record shows that he was returning approximately once a month, and that he did do it 3 times in the year 2020, which is sufficient. I'm not saying it's an obvious case, but the court should defer to the compensation judge's factual findings, and that they are sufficient to show that that there is Minnesota jurisdiction.
I think just following up, so what's our standard of review then? Is it de novo or substantial evidence in the record or a combination?
It's a combination, Judge. It's the de novo is to, if she misapplied the definition of primary duties and regularly performed. However, it's clearly erroneous in the combination of the factual findings that those were primary duties, that the pre and post trip inspections were primary duties, the fueling was a primary duty. So I think it's a combination when we're looking at this. In the case law, typically the WCCA does affirm when they're looking at the jurisdiction under the statute. Pretty much all the cases, they've even, I think was long, the court said it's arguably a close case, in concluding that the compensation judge's findings were supported by substantial evidence, meaning that the WCCA may not have found the same way on the same set of facts, but the compensation judge did.
Speaking of the case law, I want to talk about Gillen for a second. So in Gillen, this is 1992, this court said, a primary duty is a fundamental or basic part of an organized whole, citing the American Heritage Dictionary. And then not in that case, but fundamental then is defined as of central importance, and basic is, something that is the base or the essence. My question for you is, do you agree with Mr. Ferrianchek that the essence of what the employee here did was drive truck to haul vehicles?
Yes, I think that is the essence of his job, but in order to effectuate that, he still had to perform primary duties within the state. I was trying to think of a good example, and I was thinking about myself. As a litigator, I spend a lot of time during my day. I talk to clients, I'm on the phone, I'm looking at medical records, I'm summarizing things. I'm not in court that often, I'll be honest. I mean, but if I'm in court physically litigating 3 times, and this is not like a perfect example, that's litigation. That's a primary duty of my position. I can't be a workers' compensation lawyer if I'm not litigating. And I don't think that you could say litigating is in court would somehow not be a primary duty because I don't do it very often, or I'm doing it in order to get my client settlements. So I just think it's dangerous when you parse out, because the case law doesn't look at the title of the occupation or even the job, even the job description itself, but is it a primary duty? And in fueling, pre and post trip inspections, those have to be primary duties of a truck driver to haul cars throughout the state.
But the statute says regularly performs, and kind of, if I'm following your argument, wherever Mr. Brand was, whether he was in Wisconsin or Indiana, Iowa, Minnesota, he would have to do those duties. But when we look to Minnesota and jurisdiction, it would seem that 3 times over the course of 3 months, isn't that occasional and not regular?
I would disagree. Yes, that he would do that wherever he was performing. So those primary duties he performed, whether they were in the state, whether they were wherever they were. But he was a truck driver. So by the nature of his job, so he's testified in the record, he's on these long trips. So he's gone for a week. So just because, while in another type of position, maybe that would be considered less regular. However, by the nature of his job, he's doing these long weekly trips. He could be gone on a trip for 3 weeks at once. That it changes the when you're looking at, and I still don't think that would be occasional, because I don't know that you could say that it's not a specific test of a percent. So if you do this 51% or more, that is more regular. He would do it, the judge found that he returned home at least once a month. And that implies the regularity, and that he was working there for a very long time as well.
So I guess my question is, he received Indiana workers' compensation benefits. He's got we don't have to go with the lawsuit, but from what I'm kind of understanding, wherever he is, whether it would be Wisconsin, Indiana, Iowa, or Minnesota, as long as he's doing something related to his truck driving, he would be able to pursue a case, because that's where he did his duties, depending on the statute, if they were identical to Minnesota. Is that a fair understanding on my part, or am I wrong?
I don't know how it would be in Indiana. My understanding is he would have Wisconsin, because if he had elected Wisconsin, it would have been there. I don't think that if we're applying Minnesota under like a hypothetical, that if he was doing any type of employment, and he could just pick a state, because it would just it still has to go back to the primary duties. So if he's passing through I think passing through a state getting fuel would not be primary duties. The fuel in conjunction with the pre and post trip inspections, the logs, would constitute.
And he indicated, I think in the transcript, he would stop at St. Augustine, being from practicing St. Cloud for many years. I'm not sure which of the gas stations, St. Augusta, but he wasn't required to fuel at that particular place. I assume he could pick and choose wherever he wanted to fuel.
No, there was no evidence that he was required to do so. But he would be effectuating their business by, if he would have to fuel in order to transport the vehicles. And I don't think I'm going to stick to the record. So yes, I see my time has expired. May I briefly conclude?
Please answer question your best of your ability.
Can you restate?
Sure.
I just lost
There was no requirement that at that particular spot in St. Augusta, that's where he had to fuel.
No, judge.
Thank you.
I have a few questions. From what I hear you saying, based on my colleagues' questions, you believe this is a mixed question of fact and law.
I do,
And
judge.
as the fact finder, the CJ has the job of, CJ compensation judge has the job of making findings of fact.
Yes, judge.
So the request of the employer and insurer is under what standard of review? The same as yours, a mixed question of fact and law? Is this substantial evidence?
This is substantial evidence. Whether substantial evidence shows that the primary duties were regularly taking place within the state of Minnesota.
Do you believe the compensation judge's findings are in keeping with the intentions of the statute, specifically subdivision 2 of 041?
I do, judge.
And how so?
That he was performing primary duties of his employment within the state of Minnesota by fueling and do pre and post trip inspections. And that he was not merely incidentally passing through the state.
Thank you. I have nothing further.
Thank you.
Thank you.
Thank you.
Mr. Ferrionchuk, I believe you have 27 seconds.
I don't have anything further unless you do.
I don't have anything else.
No, thank
I'll,
you.
I'll save my 27 seconds. Thank you very much.
Thank you. I believe the record is now closed. I will make a statement that the motion to strike will be addressed in our opinion. A decision will be issued within 90 days. And with that, thank you all very much. It's adjourned.
Thank you.
Thank you.
Nice job.